Good afternoon, everyone, again. As I said before, I'm Francesca O'Neill. My co-host is Ian Stebbings, and this is the Thursday midday webinar from One Chancery Lane on police law. We're going to be giving you an update on some recent important decisions. Ian is going to tell you all about the important case of Parker. After he has finished with that, I am going to give you an update on 3 recent decisions about disclosure and disclosure obligations. The first of which some of you will have heard of is a case called Grice, and I'm going to spend some time on Grice because it's an Article 2 inquests decision, and that's something that takes up quite a big part of my practice. But that will come after Ian has told you all about Parker. So I'm now going to hand over to Ian Stebbings.
Thanks, Francesca. Excuse me. Welcome, everybody. Just to give you a very brief background of my practice, I practice in personal injury, police law, and inquest law. For my sins, before I came to the bar, I was a Metropolitan Police officer for some 15 years, ending up as a detective sergeant. So I'm going to look at police law today, particularly the case of Parker. And the unlawful and lawful arrest parts of it, as well as the nominal damages and exemplary damages part of it. So the topics for discussion will be unlawful arrest or lawful arrest, and that's without a warrant, not looking at whether we're going to a magistrate's court to get a warrant, although Francesca will cover some of those cases at the end regarding disclosure. We're going to look at counterfactual scenarios, which was brought up in the case of Parker. And how the judge in the first instance, Judge Stuart Smith, got that wrong and was corrected by the Court of Appeal. And then in relation to damages, nominal and exemplary, again, the first instance judge got that wrong and why he got it wrong in relation to counterfactual scenarios. And then at the end, we will look at disclosure and warrants, which Francesca will cover. So let's move on to the arrest part of itself. Many of you practice in the area of police law, which is why you're here today, and you'll be well aware of the case of O'Hara and the Chief Constable of the RUC. That's the leading case which looks at whether an arrest is lawful or unlawful. For those who don't know, the case of O'Hara involved the arrest of a man on suspicion of terrorism. The court found that 2 elements had to be present for an arrest to be lawful. The first was that an officer had formed a genuine suspicion in his or her own mind, and that's something to keep in mind. And that a reasonable man would have reached the same conclusion based on the information available at the time. And again, that's a crucial piece of information, because it matters not if that information turns out later to be in fact erroneous. So the information may be bad, but it doesn't matter, because at the time the officer formed the suspicion, if that's what he or she believed in, that's what matters. The case of O'Hara went further and stated that merely acting on the instructions of a senior officer was not capable of amounting to the grounds for necessary suspicion. However, information from other officers can raise the requisite grounds. And let me give you an example of that. One sunny July afternoon, I happened to be sitting in the CID office at Belgravia Police Station when a young police officer came up to me and said that he'd been on a raid and they had arrested a lady on the instructions of the Chief Inspector for living off immoral earnings under Section 30 of the Sexual Offences Act. So I said, sorry, can you just repeat that to me? He said, yeah, I've arrested a lady on suspicion of living off immoral earnings. So I said, you sure it's a lady? Yes, definitely, Sarge, he said. So I said, go over there and get the guide to the guiding of the word of the charges, which every good CID office has got. So we got that. I asked him to turn to Section 30 of the Sexual Offences Act, living off immoral earnings, and read me out the first line of the charge. The first line of the charge reads, being a man, you did live off immoral earnings. So immediately he read that, he realised the mistake he'd made. He'd arrested that woman on the say-so of a chief inspector. So I told him to go down, dust her off and let her go, which is exactly what happened. So that officer didn't have the requisite grounds for arresting that person just because the chief inspector told him to. Converse that, however, of a drug squad officer on observation who sees a drug deal go down and imparts that information to other officers who are on the street, that Mr. X has passed Mr. Y a package and money has changed hands. He's not going to make the arrest. The officers on the street are going to make the arrest. So he's imparting the reasonable grounds to those officers who may well not have seen that drug deal go down. So that's the case of O'Hara, and that's what that says. Now let's turn to the Parker case. It's Parker versus the Chief Constable of Essex Police, 2018, EWCA Civ 2788. Instructing solicitors in this case were our good friends from DAC Beechcroft, and they instructed Lord Fawkes QC of 1 Chancery Lane, amongst others, and it was Lord Fawkes's argument that was the main thrust of the argument in regards to nominal damages. It's called the Parker case, but it's known more by its colloquial name as the Michael Barrymore case, because Michael Parker is in fact Michael Barrymore. And many of you will know the initial facts of that case, but I'll just cover those in some more detail, because the detail is quite crucial to what was argued at both first instance and at the Court of Appeal. So in the early hours of the 31st of March 2001, Stuart Lubbock was found unconscious and not breathing in the swimming pool of Michael Barrymore. He was dressed only in boxer shorts. He subsequently died in hospital at 8:23 a.m. that morning. Police action to secure the scene was inadequate, unfortunately, and the death was then investigated on suspicious circumstances. 2 of the 8 house guests that night, a Mr. Kenny and a Mr. Merritt, were arrested on suspicion of murder, but Mr. Parker, Michael Barrymore, was not. And the reason he wasn't arrested is because he had left the premises prior to the arrival of police and gone to a flat with a bag of clothing possibly, but it was never found what he was carrying. And then he then booked himself into a hospital facility. A coroner's inquest returned an open verdict, but no one was charged with the murder of Mr. Lubbock. The initial investigation was concluded in December of 2001. There was a further inquiry in 2003, and that was as a result of Mr. Barrymore's challenge to the conclusion of a pathologist, but the investigation wasn't formally reopened until 2006. Now, that investigation was led by Detective Superintendent Wilson. Part of his team consisted of Detective Constable Jenkins, who was the exhibits officer, and Detective Constable Thomas, who was the case review officer. And it's crucial to remember those 2 names. Following a investigation by Detective Superintendent Wilson's team, it was decided by the case review officer, in conjunction with Detective Superintendent Wilson, that a simultaneous arrest would take place on the 14th of June 2007 of Mrs. Parker, Kenny and Merritt. With respect to the arrest of Michael Barrymore, the officer tasked with carrying out that arrest was in fact DC Jenkins, the exhibits officer. She was well aware of the evidence that had been gathered and the reasonable grounds to suspect Mr. Parker for committing the offence of murder. And it was therefore necessary for her to conclude that the arrest was in fact necessary. It's important to note at this point that surveillance officers, prior to the arrest of those 3 men, had been deployed the night before. However, those surveillance officers were only told to follow the 3 men. They weren't told why, and they weren't told the fact that they were likely to be arrested the following day. They certainly weren't given enough grounds to arrest any of those three men. The following day, on the day of the arrest, DC Jenkins, unfortunately, was detained in traffic and couldn't make the arrest when at the same time as the other two participants were arrested. Therefore, one of the surveillance officers was ordered to make an arrest, which he did. Following the arrests, an interview and further investigation, no new information came to light, and the CPS advised that there was subsequently insufficient evidence to bring charges, and the parties were informed accordingly of this fact. And subsequently, in 2013, Mr. Barrymore brought proceedings against the Chief Constable of Essex Police for unlawful arrest, false imprisonment, and sought damages in the region of £2.4 million because of the impact that it had on his career. Now, initially, the Chief Constable of Essex contended that the arrest was lawful, but in 2016, it was accepted that the arrest was unlawful, and it followed, therefore, that there must have been false imprisonment. The reasons for that admission, it will come as no surprise and shock to many of you, was that the arresting officer, the surveillance officer, did not have the requisite reasonable grounds for necessary suspicion to justify an arrest under section 24(2) of PACE. And as I say, that touches upon the O'Hara principles in regards to giving another officer requisite grounds. If we then turn to the counterfactual scenarios that were argued in the first instance hearing. So Mr. Parker, Mr. Barrymore, sought substantial damages. The alternative argument that was put forward by the Chief Constable of Essex was he was only entitled to nominal damages because he would have been lawfully arrested in any event. Two scenarios seem to play out from that. The first scenario is this, that the surveillance unit could have kept Mr. Parker under observations until DC Jenkins arrived at their location. She then could have effected the arrest, having the reasonable grounds, having been part of the inquiry team. Or the other counterfactual scenario was that DC Jenkins could have been contacted by the surveillance team. She could have then imparted the knowledge that she had to the surveillance officer, and that surveillance officer could have then arrested Mr. Parker. So the argument was that he would have been arrested in any event. The first instance decision, the matter came before Mr. Justice Stuart Smith, and in 2017 he held, quite rightly, that Mr. Parker could have been lawfully arrested by DC Jenkins, but that he was nevertheless entitled to substantial damages for false imprisonment because he'd not been lawfully arrested by the surveillance officer. And had he had been arrested by any other surveillance officer who was present, again, it would have still been unlawful because they did not have the requisite grounds. Now that perhaps goes back to the briefing given by the arrest team and the inquiry team. The surveillance officers weren't briefed entirely as to the evidence that they had against Mr. Parker, Mr. Merritt and Mr. Kenny. The trial judge found that there was no alternative to the designated officer arresting Mr. Parker, nor did any officer from the inquiry team give thought to the legal requirement as to the state of mind of the arresting officer. So what did that arresting officer know at the time that he was arresting Mr. Barrymore? He found that if DC Jenkins was not available to arrest Mr. Parker, then no other officer could have lawfully done so. Well, we know that that can't be right because DC Jenkins could have imparted what she knew to another officer. The judge then, having found that no other officer could have lawfully arrested, turned to the issue of damages. The judge looked at the principles that are derived from the leading cases in regards to damages, whether they be exemplary or nominal damages. Many of you will know the Lumbar principles, which is set out in the case of R. Lumbar versus the Secretary of State for the Home Department in 2011, and the other two cases, Kambadzi and Bostridge. In relation to those cases, the first two of the leading cases relate to Home Office detention orders made against individuals, and they concerned detention, one which was derived from an unlawful policy, and the second was derived from the failure to carry out an essential review of the person's detention. The case of Bostridge was a case which related to a mental health patient from the NHS, and the NHS had failed to carry out statutory review requirements. The person detained, however, would have been detained in any event, and they suffered no loss as a result of their detention. So if we look at the trial judge's findings in relation to that, on the facts. So on the facts, the judge found that all the evidence pointed one way as to whether Mr. Parker would have been arrested lawfully. The surveillance had not been sufficiently briefed, but in the notes made by the case reviewing officer, Detective Superintendent Wilson stated that Mr. Parker was to be arrested come what may, but the surveillance team lacked the requisite knowledge under O'Hara, and there was no evidence that any officer had borne this in mind before, during or after the arrest. And there was no alternative plan to lawfully arrest Mr. Parker. There is further evidence by the fact that he was not lawfully rearrested subsequently. So what could have happened in that scenario was that the surveillance officer could have detained or arrested Mr. Parker, and then when DC Jenkins arrived, she could have then arrested him again, as it were, but this time it would have been lawful because she would have had the requisite grounds, whereas the surveillance officer didn't have the requisite grounds simply because he hadn't been briefed properly. Now, I completely understand from the briefing that the briefing was given on a need-to-know basis. Certain officers needed to know certain facts. The surveillance team didn't really need to know the facts of the investigation, whereas DC Jenkins and DC Thomas were well aware of the facts because they were party to all the information, having been part of the investigation team. However, what should have happened from a policing level was that those surveillance officers should have been imparted with enough information that they needed to make the arrest if they needed to. So that was the plan B, if you like. But no, there was no plan B in this scenario. So the points of appeal after the judge decided that Mr. Parker was entitled to substantial damages, 3 grounds were advanced by Lord Fawkes. The first of those grounds was that Parker could and would have been arrested had the officers acted lawfully. The second ground was that the judge had constructed wrong counterfactual scenarios, namely what would have been the position if the surveillance officers had not arrested him. And the third ground that was advanced was the judge's suggestion was wrong, that limiting the claimant's entitlement to nominal damages would undermine constitutional protection regarding the O'Hara principle. There was strong public interest in applying the Lumbar principle to situations where an officer could lawfully have arrested a suspect, but was unlawfully arrested by another. So those was the 3 grounds that were argued. The Court of Appeal found that if the power to detain had been exercised by the application of a lawful arrest, then it is inevitable that the defendant would have been detained. So what does that mean? In short, it means this: they have suffered no loss or damage as a result of the unlawful act, because they would have been arrested anyway. So hence, it must follow that they should receive no more than nominal damages. And this is the crux of that case. The Court of Appeal found that the test was not what, in fact, would have happened had the surveillance not arrested Mr. Barrymore, but what would have happened had it been appreciated what was the law was required. And that's down to the briefing of the officers by the briefing team previously. Had they looked at what was required by law, i.e. the requisite grounds to give each officer to arrest the three individuals, that would have been contemplated when they made the briefing, but it wasn't. So that's what the court found. It's quite clear from what the Court of Appeal found that Mr. Barrymore would have been arrested regardless of the unlawfulness of the arrest by the surveillance team. So that's what the Court of Appeal found. As a result of that, Mr. Barrymore was only awarded nominal damages. If we then carry that forward further, there are recent cases which have built on the case of Parker. And it's this case, it's the case of the application of Terence Norman and others, again versus the Chief Constable of Essex Police in 2020. And this case concerned the execution of a search warrant at the Norman's home address, which was Roper's Farm, in 2019. And it concerned a fraud investigation into a company called Blue Tractor. There was some suggestion that it was a Ponzi type fraud, but there was no actual evidence of that subsequently. A policy decision was made by the DI in charge, and his policy decision was to arrest all adult members of the family present at Roper's Farm. Many of you will be familiar with policy documents. Those policy documents are paramount when it comes to looking at what decisions are taken in regards to a major investigation. They're not normally used in minor investigations for obvious reasons. But in major investigations where they are used, those policy documents and policy decisions made by the officer in charge need careful scrutiny as to what the team were going to do, who was going to be arrested, what inquiries were going to be undertaken. In this instance, the DI decided that all adult members of the family at Roper's Farm would be arrested. Unfortunately, there were a number of failed attempts at obtaining a warrant. There was a number of times where the warrant had to be altered. And eventually, after much to do, warrants were granted for both Roper's Farm and the offices of Mr. Norman. On the day of the arrest, the house was entered, but when officers turned up at the offices of Mr. Norman, it turned out that those offices weren't in fact Mr. Norman's offices. They were the offices of an accountancy firm who had nothing to do with the Normans. An entry was therefore refused. Now, I have a bit of a problem with that because it's clear that someone didn't do their intelligence work properly, because had they done their intelligence work and visited their premises perhaps before surreptitiously, just to have a look, they would have come across the fact that it was an accountancy firm and not wasted the time of the judge in gaining a warrant for that premises. So again, that's something to look at. So the house was entered, various items were seized. The Normans then raised complaints about the lawfulness of both the warrants and the arrest. Subsequently, on arrest, all family members were not arrested. The only person that was arrested was Mr. Norman himself. It was conceded subsequently by the Chief Constable of Essex that the search warrants should be quashed. And the reason for that was because they disclosed no authority to seize certain items. As I'm sure some of you, most of you know, that the warrant has to detail what items are to be seized. Items that were seized were not contained within the warrant. So that had to be quashed on that ground alone. No statutory authority was ever cited for the issue of the warrant. And again, I question what the judge was doing when he looked at the warrant, and basically it looks to me as if he just rubber stamped it. No offences were particularised on the warrant. And again, perhaps this is down to the officers who put the warrant together. Why no offences were detailed on the warrant and what statutory authority they had for the issue of the warrant not being included is beyond me, but there we are. And the court's approval of each page of the warrant was not marked. Normally, when a warrant is granted, as I'm sure many of you know, the court will endorse the bottom of every page to approve that page itself. Again, that wasn't done. And it was further conceded by the Chief Constable of Essex that there'd been a failure to give proper disclosure to His Honour Judge Gatwick. Now, again, that causes me some concern that officers are not disclosing everything they should to a judge when they're obtaining a warrant. However, looking at the arrests themselves, the arrests were deemed lawful because at the time of the arrests, the officers who were briefed to arrest both Mr. and Mrs. Norman, they suspected that they had committed offences of fraud. They also had a warrant signed by a judge to back up those reasonable grounds. And the court held that because of that, those warrants, or those arrests, sorry, were lawful. So that concludes that sort of section. It builds upon the Norman case, builds upon the Parker case. And again, because the arrests were lawful in this case, no damages were awarded. We're going to go on. I'm going to pass you back to Francesca because you've had me talking at you for half an hour, and I'm sure you want to hear a change of voice. So I'm going to pass you over to Francesca to look at some recent disclosure cases, which builds upon some of the things that I've touched on in regards Parker and regards Norman.
Thank you very much. Thank you very much, Ian. That was really interesting deep dive into those cases. In particular, there are all sorts of interesting tidbits which just keep coming out of that Michael Barrymore case. It seems to have happened such a long time ago, and it's still relevant. I am going to talk to you all about three cases. The first is the Crown on the application of Grice and Her Majesty's Senior Coroner of Brighton and Hove. This was a 24th of December 2020 decision, so quite recent. And it's an interesting case on several levels. But the level that I'm particularly interested in, that fits in particularly with my practice, which, like Ian, is personal injury, inquests and police law, but also clinical and professional negligence. So I have an interest from the clinical negligence point of view on the application of Article 2. Some of you may have attended the webinar that I delivered with Dominique Smith last year on Article 2. If any of you did or didn't, but want to see it again, it's available on the Chamber's YouTube channel. After that webinar, another important decision was handed down by the Court of Appeal in a case called Maguire. I wrote an article about Maguire, and if anyone is interested in reading that, please let me or Emma in Chambers know, and we're happy to send you a copy. But this very much builds on the application of Article 2 to police investigations. And I'm going to start with Grice because I think it's probably one of the most important decisions on the application of Article 2 and whether or not that is properly discharged by a police investigation. So hold on to your horses, because I'm going to canter through this pretty quickly. We've only got, I'm going to try and get through by 10:02 so that we've got time for some questions and discussion. So in Grice, the High Court summarised the scope of the requirements under ECHR Article 2 for an effective investigation. Essentially, a coroner had been correct to refuse to reopen the inquest into the murder of a woman by her former partner after her complaints of stalking were mishandled by police, while the criminal trial by itself had not satisfied the Article 2 investigative obligation. A number of further investigations into those police failings had collectively met the Article 2 obligation. The facts are unfortunately very sad. A mother sought judicial review of a coroner's decision not to reopen the inquest into the murder of her daughter following a criminal trial. I won't spend too long on the facts of the underlying case, but this was a very sad tale in which the deceased had been in a relationship with a man. Go away. I apologise, my phone is connected to my headphones. A mother sought judicial review of a coroner's decision not to reopen the inquest into the murder of her daughter following a criminal trial. Sorry, I'm catching up on my own notes. The deceased had been in a relationship with a man. They'd broken up. The man had continued to harass and stalk the deceased. She had made complaints to the police. They had given the man a warning, but done nothing further. Even after an assault, the man was released without charge after showing the officers text messages which appeared to indicate that he still was in a relationship with the deceased. And in fact, because the deceased had failed to tell the police that she'd been in a relationship with this man, she was given a fixed penalty notice for wasting police time. Further incidents occurred, but the deceased did not report them to the police because she was too afraid of getting into further trouble, not being taken seriously. Unfortunately, man obtained the key to her home, broke in, and murdered her. The sentencing judge made public remarks directed to the IOPC about the inadequacy of the police response to the deceased's complaints, and a number of further investigations of the police actions were carried out subsequent to the murder and subsequent to the criminal trial. So the IOPC undertook an investigation. A domestic homicide review was undertaken by an independent chair. The Inspectorate of Constabulary Fire and Rescue Services inspected Sussex Police, and police disciplinary proceedings, which resulted in findings of misconduct against 3 officers, all took place. All of the reports that came out of those investigations were critical of Sussex Police and made recommendations for improvements. So those all took place and ran alongside a criminal trial and an inquest. And so we had a multiplicity of investigations, all looking at particular parts of the failure of Sussex Police to prevent this death. It was accepted that the investigative obligation under ECHR Article 2 was engaged on the basis of a potential breach by the police of their operational duty to safeguard the deceased's life. And the issue for the High Court was whether the coroner had been right to hold that the criminal trial and all of those other investigations were sufficient to meet that obligation. The judgment is a thorough, detailed and very helpful judgment, and I would recommend that anyone interested in this area of law goes and has a look at it, because the beginning sets out the general provisions and principles governing inquests and the suspension of inquests when there's a criminal trial taking place, and whether or not the coroner's decision not to resume the inquest was inconsistent with Article 2 or was irrational under the Wednesbury principles. I'm not going to go into any of that in huge amount of detail, we don't have time, but it is all very clear in the judgment and I'd really recommend it. So let's remind ourselves, what are the requirements of Article 2? They are variable according to the circumstances of the case, but there are certain irreducible facts, and those of you who are familiar with this area will recall the case of Jordan and the United Kingdom. It's an important 2003 decision of the Supreme Court. The authorities have to act of their own motion. The investigation has to be independent, effective, and reasonably prompt. There has to be a sufficient element of public scrutiny of the investigation or its results to secure accountability, and the next of kin needs to be involved to the extent necessary to safeguard their legitimate interests. And so in this case, Jordan was applied, and it was very much on the basis of that framework that the High Court was able to come to its conclusion. But it was also important, the High Court found, to decide what was not required. So no particular procedure has to be adopted to fulfill the Jordan requirements. The requirements could be met by separate investigations rather than a single unified procedure. The requirement for a family to be involved did not mean that the authorities had to satisfy their every request for a particular step to be taken in the investigation. The requirement for public scrutiny did not invariably require a public hearing, nor did it mean that the family had to be able to directly test the evidence themselves. So, for example, some of the investigations I outlined, there's no facility for the family to cross-examine officers in a disciplinary procedure that's internal to a police force. The family took issue with that, but the High Court found it was not required. And there was no requirement that each element of the investigative procedure met each one of the tests. The question was whether, viewed in totality, the investigations met the minimum Jordan requirements. So, did the investigations meet the Article 2 obligations? The following matters were found to be relevant. The murder trial was not sufficient alone because it became apparent that serious police failings contributed to the death. However, it did more than decide the criminal responsibility of the man who committed the murder. The sentencing judge's remarks brought public attention to the police failings and prompted the IOPC and DHR investigations. The IOPC provided a detailed and comprehensive report. The DHR carried out an independent inspection and published a report noting causes for concern. The HMIC FRS report provided further oversight. The disciplinary proceedings ensured that the officers involved were held to account and the family was sufficiently involved. Altogether, the inquiry satisfied Article 2 and the coroner's decision not to reopen the inquest was correct. And so the application for judicial review was refused by the High Court. I'm sorry that I've had to go through that so quickly. There is a lot to go through, and this is, as I said, I would really recommend anyone interested in this to go and have a look at the case. It is going to be cited, I think, as often as Jordan going forward, because it contains so much useful and helpful commentary on what the criteria what are the criteria and the requirements and how they can be fulfilled. Can I have the next slide, please, Ian? This is my Chris Whitty moment, by the way. I'm next going to talk to you about a case called Skelton, Crown on the application of Skelton and the senior coroner for West Sussex. This was a 23rd of October 2020 case. Again, it's unfortunately centres over the facts of a murder. It's, in this case, the claimant's parents applying for judicial review of a coroner's refusal to carry out a full Article 2 inquest into the death of their daughter. What was the finding of the High Court? A coroner had erred in law in holding that there had been no arguable violation of Article 2 where there had been alleged failures by the police in the investigation of the circumstances of a woman's murder. The court ordered an Article 2 compliant inquest into the death. Again, A woman was murdered by her partner in 2011. Her death was investigated by the police, who initially considered it as non-suspicious. Following a campaign by the claimants, a re-investigation began in 2016, leading to the conviction of the woman's murderer. In light of the conviction, the original inquest verdict of accidental death was quashed, and the coroner indicated that she intended to list a short hearing to record the cause of death as unlawful killing. But the claimant sought a wider inquest to the circumstances of the death, and in particular an investigation as to whether the circumstances involved breaches by the police of duties imposed by Article 2. The claimants maintained that those breaches arose not only in relation to events shortly before the death, but also in relation to the investigation into the death of the murderer's former partner some 5 years earlier. That death was also treated as non-suspicious at the time, but following the renewed investigation, the murderer was convicted of manslaughter in respect of that death, as well as their daughter's death as well. The claimants argued that the available material disclosed arguable breaches by the police into substantive Article 2 duties in failing to conduct an effective investigation into both deaths and to protect their daughter in the months preceding her death, because of course I suppose it was their point that had the previous death of the partner been investigated, their daughter might have been protected and the police might have gotten more involved. The claimant submitted that the coroner had been wrong in holding that they'd failed to advance an arguable case for the purposes of Article 2, and that on an application for judicial review, the court should determine for itself whether there was an arguable case. The application was granted. There was an arguable case under Article 2. The obligation to initiate an effective public investigation into a death occurring in circumstances in which a substantive obligation might have been violated and state agents might be implicated was usually fulfilled by a full inquest, asking and answering the question, in what circumstances the deceased died, and thereby broadening the scope of the traditional coronial inquiry. You'll all be familiar with Middleton. The threshold for the procedural obligation to arise was that anything that was more than an arguable breach of Article 2 indicated that the substantive obligation arose and needed to be investigated. Arguable meant anything more than fanciful or a credible suggestion. And so the coroner had been wrong to decline the parents' request that a full inquest was held, and a new inquest on the Article 2 basis was going to have to take place. I'm going to, next slide please, Ian. The next case and the final case I'm going to discuss with you today is the Crown on the application of Jordan and the Chief Constable of Merseyside, not to be confused with the very important case of Jordan that I discussed before when I was talking to you about Grice. These are different cases. This is a case on a totally different subject. It's got nothing to do with Article 2. This was a Misuse of Drugs Act case, and it was about the application of a warrant to search a claimant's home. So much more in keeping perhaps with the Barrymore line of authority that we have been discussing. The claimant applied for judicial review of a decision to issue a warrant to search his house. What were the facts of this case? I won't spend too long on them. The warrant had been issued in July 2019 by a magistrates court under the Misuse of Drugs Act on the basis that the claimant's home was being used to store drugs. Reliance was placed on 14 police intelligence reports. All but 2 of the reports had a high confidence rating. Report 13 stated that in February 2019, a warrant had been executed at the claimant's address and that a large quantity of cash and cannabis had been found and the claimant had been arrested. £2,130 in cash was found, but that report had not been referred to in Report 13. The factual basis for the application was disclosed in redacted form to the claimant. The redacted portions were the subject of a claim by the defendant Chief Constable for Public Interest Immunity, which was upheld. Obviously, there was a drugs investigation ongoing here. What did the claimant submit? The claimant submitted that the warrant had been granted on the basis of a deliberately exaggerated account of the execution of the previous warrant on the 20th of February, and that there were material non-disclosures about that search and subsequent occasions on which police officers attended but had found nothing of interest and no further action had been taken. He argued that Report 13 gave a false narrative that the search on the 20th of February had been a successful drug search of his property, and implied that the intelligence that formed the basis for the grant of that warrant was reliable. The application for judicial review was refused. What was the duty to disclose? When considering a challenge to a search warrant on the ground of non-disclosure, 2 questions had to be asked. Number 1, whether the applicant had failed to disclose something which he was legally obliged to disclose, and 2, if so, whether the non-disclosure was material. If there was a point that could properly be made against the grant of the warrant, but the applicant thought that there was an answer to it, he might be legally obliged to disclose both the point and the answer. It was for the issuing authority, not the applicant, to decide whether the answer was a good one. In answering the first question, it was important to bear in mind the applicant's duty to disclose to the magistrate anything that was relevant to the satisfaction of the statutory test for the grant of a warrant. In answering question number 2, the test was whether the information that was alleged should have been given to the magistrate might reasonably have led to a refusal to issue the warrant. In this case, the police had not complied with their disclosure obligation in respect of the outcome of the search on the 20th of February. The fact that the information relied upon to justify the warrant included Report 13, and that indicated that they considered the outcome of that search was material. The discovery of the cash was relevant if and only there'd been no proper explanation for it. To say simply that a large quantity of cash had been found might have conveyed the impression that there had been a successful drugs raid, which was not in fact the case. The search was actually for a Class A drug. However, the court considered the materiality of the non-disclosure. To assess materiality, it was necessary to look at what would have been before the magistrate if the police had complied with their disclosure obligation, and then put that into the context of the other information on which the application was based. The court considered the unredacted version of the application form. For reasons that could only be given in closed form, even leaving the outcome of the search entirely out of account, the information contained in the application form was not such that the magistrate could not reasonably have refused the warrant, and so it was not material. This is an important case because it might be thought that all police officers failing to follow the appropriate procedure might fall foul of a judicial review application on that basis, but that's clearly not the case. It is going to come down to materiality. Those are the 3 cases that I am going to speak about today. Of course, there's so much more to discuss, and if anyone has any questions about it, please do feel free to let us know, either by putting them into the Q&A box, or, as I suspect there won't be very much time left, please do feel free to email either me or Ian, and we'd be really happy to look into anything arising from any of those decisions. Ian, I'm going to hand back over to you, I think, for the final slide. Is that right?
Yeah, thanks, Fran. Thanks for that. That was really interesting. Very quick run through. Just something worthy of note, looking at those 3 cases and the other 2 cases that we've looked at, the Parker and Norman case. I think it's worthy of note that officers need to turn their minds to what the law requires when carrying out their duties. Unfortunately, many of them don't at the moment, but also what comes out of those cases is we as lawyers can't hide behind the guise of, well, he would have been arrested anyway, because whilst that may give the defendants a way out of having to pay exemplary or aggravated damages, the court was at pains in the Parker case to point out that this should not give rise to reckless stroke slapdash approach by police officers. So, and again, I think the case of Jordan that Fran has just touched upon is in a similar vein. One light-hearted note that I think Fran wants to draw your attention to, which we saw during the week, I don't know if many of you saw it, it is this. who knew it was offensive, an offence to be offensive? I think there's plenty of lawyers that could have committed this offence, I think, and maybe I'm included as one of them.
Well, we'll try not to in the webinar. No, I thought it was potentially of some use, although we really don't have time to get into it. But those of you on Twitter will have seen that this was posted by, I think, Merseyside Police, a photo of police officers in front of an ad van, very proud, being offensive is an offence, and then got into really hot water about it. And in fact, the chief inspector then had to put out a fairly grovelling apology saying, no, we know that being offensive is not an offence. Hate crime, on the other hand, is an offence, which I think nobody has a problem or issue with. But for those of you who are lawyers working for police officers, I'm sure you will let out emitted a groan at that point. It's really important that you communicate with your police officers and that they feel able to come and seek your advice before going to the printers with stuff like this, because it's really essential, in my view, that especially a public-facing campaign like this gets the law right. And so it's really a word of warning to everyone. You know, run this past your lawyers before you get the van out. A question has been asked, Ian, by an A. Holland.
Yes.
Which
I'll
I'm
deal
going to
with the
deal
other
with.
questions first. That may answer that question. So we've had a couple of questions in previously. Thank you, Christine Billet. I hope I've pronounced your name right. Who is a solicitor at Joint Legal Services, Stafford Police, and West Midlands Police. I'll read the question out so that everyone's aware of where I'm going. I have various cases where claims for unlawful detention / arrest are being made, where the officer places their hands on the claimant in order to usher them to another place to get more details from them, or to take them outside in order to calm them down. In both cases, unlawful detention arrest is being claimed, but surely there must be some measure of flex to enable officers to exercise their duties in taking people to one side, etc., to calm them down and diffuse situations without it amounting to detention or arrest. Where is the common sense of proportionality in such matters, and how do we overcome these common scenarios? So I think it's a very important question that's been raised. The answer is fairly simple, to be honest. An officer has no lawful power to detain someone for questioning, and a person is not obliged to answer. That's common practice. There are exceptions to that rule, one being a Section 60 Criminal Justice and Public Order Act order, and an order under the Terrorism Act of 2000, if they are in force. There are two cases that spring to mind from that question. The first one is Walker versus the Commissioner of Police for the Metropolis, which is in 2014. And I know some of our Met Police solicitors are here today, and they may well have been instructed in this case. In that case, the police officer blocked Mr. Walker in a doorway, preventing Mr. Walker from leaving whilst the officer sought to question him. But the officer hadn't intended or purported to arrest Mr. Walker at that stage. Mr. Walker's detention lasted only a matter of seconds, because subsequently to being stopped walking out the doorway, he became violent towards the officer, assaulted the officer, and was subsequently lawfully arrested by the same officer. The High Court found that he was unlawfully detained, but took a pragmatic approach and awarded him the princely sum of £5. The other case that comes out of that is Collings versus Wilcott, which is an old case from 1984, where a police officer, without exercising his power arrest, sought to stop and detain a person with the actual use or threatening of force. The court decided that the act of detention in that case was unlawful. There is no power to stop and detain someone. In this case, it was a prostitute who walked away on being cautioned for prostitution. She was seen by police officers soliciting men in street with another prostitute, and when the police officer spoke to one woman, she agreed to be questioned, but the defendant refused and walked away. The police officer took hold of her arm to restrain her, and she swore at him and then assaulted him. She was subsequently lawfully arrested for assaulting a police officer. When it came to court, she was convicted, but that conviction was subsequently overturned on appeal because at the time the officer took hold of her, he was not acting in the lawful execution of his duty, because there is no power to retain and arrest somebody whilst cautioning them for the purposes of prostitution. And it's perhaps relevant to look at Lord Justice Gough's judgment in that case, and that case is well worth a read. He says this: if a police officer restrains a man, for example, by gripping his arm or his shoulder, then his actions will also be unlawful, unless he is lawfully exercising his power of arrest. A police officer has no power to require a man to answer him, except in the lawful exercise of his power of arrest. The lawfulness of a police officer's conduct is judged by the same criteria as are applied to the conduct of any ordinary citizen of this country. So that answers that. There are a couple of more recent cases that you can have a look at, Christine, which is Wood versus DPP 2008, where an officer was involved in holding the arm of a person in order to question but didn't arrest them. And the other one is D versus DPP 2010 EWHC 3400, and that looks at whether a person is detained with a question of fact and degree rather than a question of law. So is a person detained or not is not a question of law. It has to look at the facts of each case, providing within that legal framework that the person has acted reasonably. Hopefully that answers your question. Moving on to question 2 that we got was from Tim Stafford from Thames Valley Police. Thanks for this, Tim. Says this: can the Thompson tariff be reasonably adjusted downwards for detainees used to custody and also for arrest of a few minutes? The simple answer to that is yes, it can. As many of you will know, there is what's termed the initial shock award, and this was cited in the case of Thompson versus the Met Police in 1998. The citation for that, if you need it, is 1998 Queen's Bench 498. And that makes clear in that case that all cases are fact sensitive. But the initial shock award was cited in Thompson because it will be lower for someone who is used to being arrested or used to being placed in custody. So for your 78-year-old grandmother who's arrested for the first time in her life, the initial shock award will be much higher than from your 45-year-old long-time bank robber who is used to being arrested by all and sundry. So that case, it can be adjusted downwards, and obviously an arrest for a few minutes I've already cited in the case of Walker versus the Commissioner of Police. The Thompson case was recently reviewed, again in another case against the Commissioner of Met Police, in the case of Rees, 2021 EWCA Civ 49. That's the latest case that looks at the imposition of damages and how damages are awarded. Just looking at one last case in regards to that, the guideline case for damages is the case of MK Algeria versus the Secretary of State for the Home Department 2010 EWCA Civ 980. And that decided three things: that the award of damages is fact sensitive. That builds on what was said in Thompson. Damages should reflect the period of detention taken as a whole, and damages increase with the passage of time but taper downwards. So it's not a sort of £500 an hour for every hour. It may be £500 for the first hour and then drops off accordingly. if you look at that, the case of MK Algeria and Secretary of State, it will revert you to the cases that we've cited before, which is KG versus the Secretary of State for the Home Department, the case of Diop, and the case of Majeski. Those are 3 cases that we'll find as well.
Ian, I think we're running out of time, and I know
yes.
that people are starting to have to go because I think everyone's in their lunch hour.
Yep.
What I was going to suggest is if you've got a question and we haven't got to it, please do feel free to email either one of us, and we will try and get back to you ASAP. I think, yes, that's it. That's what I was going to ask you. Ian, those are our email addresses. Please don't hesitate to contact us if we can be of assistance. We really hope that you've enjoyed and found this webinar informative and useful, and we hope that you have a really fantastic day. So thanks very much, Ian. Sorry about the interruptions and the banging. I'm just trying to move into my house, and that's why there are boxes everywhere.
Thanks very much, everybody, for attending. Thank you very much.
Thank you so much. Thank you. See you soon.
Bye now.
Bye-bye.